Ladies and gentlemen, excellencies, colleagues, it is my honor and privilege to welcome all of you to this briefing organized by Iceland, Liechtenstein, the Netherlands, Ukraine, and my own country, Latvia. I would like to take a moment to express our gratitude to all of you for joining us today here, and those of you joining online. Your presence here reflects your dedication to justice, values vested in the UN Charter. Russia's unprovoked war of aggression in Ukraine has inflicted profound suffering upon people and is leaving a trail of destruction. As advocates for peace, accountability, human rights, and rule of law, we believe that the register of damage caused by aggression of the Russian Federation against Ukraine is the first component of the comprehensive compensation mechanism that is meant to enforce Russia's international law obligation to make reparation to Ukraine, as it helps victims record their losses and safeguards evidence to support future claims for compensation. I would like to take this opportunity to congratulate Markian Klichkovsky, who recently was appointed as the Executive Director of the Register of Damage. Now, without further ado, let me introduce our esteemed panelists who have graciously accepted our invitation to share their knowledge and expertise with us today. The first speaker will be my colleague Sergei Kislitsa, Permanent Representative of Ukraine to the United Nations, who will have a statement titled Laying the Foundationals to Accountability. He will be followed by Mrs. Irina Mudra, Deputy Minister of Justice of Ukraine, who will have a statement titled Reparations for Victims of Russia's Aggression. Then the next speaker will be Mr. Markian Klichkovsky, Executive Director of the Register of Damage, who will have a statement titled Register of Damage, setting up the first steps towards compensation mechanisms and reparations. Then His Excellency Thorundur Aegir Oskarsson, DPR of Permanent Mission of Iceland, will share the highlights of the recent Reykjavik summit in May. I will make the national statement later on, then it will be followed by the brief Q&A session. So I encourage you to actively participate by asking questions and engaging in meaningful dialogue. Your thoughts and contributions are vital as we strive to foster an open and inclusive environment for exchange of ideas. And last but not least, my colleague Christian Venavesser, PR of Liechtenstein, will deliver closing statement and closing remarks. I truly believe that each panelist will bring a unique perspective on the topic of the register during today's briefing. Please, Sergei, the floor is yours.
Well, thank you. Dear colleagues, dear friends, I would like to express my sincere gratitude to all who continue to support Ukraine in this grave time of war, and for commitment to work closely to ensure justice for victims of atrocities following the aggression against Ukraine. During the invasion, the Russian armed forces have committed and continue to commit multiple war crimes against the civilian population, as well as crimes against humanity. Thousands of Ukrainian civilians, including children, are being killed in Ukraine within the reach of the Russian army. Regular missile terrorism, abduction of Ukrainian children, and blowing up the dam at the Kakhovka hydroelectric power plant have testified that it was the Russians' plan to commit genocide, crimes against humanity, and war crimes. Against this backdrop, Ukraine has supported several initiatives aimed at delivering justice for the crime of Russia's aggression against Ukraine, such as comprehensive compensation mechanism for the damages arising out of Russia's invasion of Ukraine. The main topic of today's briefing. A mechanism for compensation for damages which would be designed and adjudicate claims for damages from individuals, businesses, as well as the state of Ukraine. With this important aim at the forefront, Ukraine, together with partners, some of whom are present in this room, began its work on the resolution furtherance of remedy and reparation for aggression against Ukraine, adopted on the 14th of November 2022. And it laid the fundamentals for the establishment of the Register of Damages caused by internationally wrongful acts of the Russian Federation in or against Ukraine. However, being an important pillar of a comprehensive compensation mechanism, the Register of Damages itself is not the final aim, but rather one of the steps toward achieving comprehensive accountability. In this regard, I am pleased to give the floor to Ms. Irina Mudra, Deputy Minister of Justice of Ukraine, followed by Markian Kluchkovsky, still advisor to the Office of the President of Ukraine, and recently appointed Executive Director of the Register of Damage caused by the aggression of the Russian Federation against Ukraine, who are here today to speak about the current situation and future plans on the track of establishing the comprehensive compensation mechanism. I would like to say that I'm also very much appreciative of the initiative of my colleagues to have this event today, because it shows the transparency of how we approach this issue, the willingness not only to follow on the resolution that was adopted by the General Assembly, but also to keep everyone who is willing to be informed on the recent developments. And without further ado, I give the floor to Irina. Irina, you have the floor, please.
Thank you, Ambassador. Dear ladies and gentlemen, Your Excellencies, I'm pleased to welcome all the distinguished participants of this event, and I'm grateful to the permanent missions of Latvia, Iceland, and the Principality of Liechtenstein in the United Nations for organizing this briefing on the Register of Damage and the opportunity to present before you today. On behalf of the government of Ukraine and every Ukrainian, I would like to thank you and your governments for the unwavering support and commitment to Ukraine in upholding our sovereignty and territorial integrity, as well as your solemn position on Russia's actions as an aggression, a blatant violation of the UN Charter and international law, egregious violation of international order, serious breach of peremptory norms of international law by Russian Federation, called for a decisive international response. And on November 14, 2022, at the emergency session of the General Assembly on the United for Peace resolution, the UN reminded that for Russia to pay for injuries that it caused in Ukraine is not merely an ethical and moral imperative. It is a legal obligation under the international law principle of state responsibility. The UNGA resolution on furtherance of remedy and reparation for aggression against Ukraine made it very clear to the aggressor state that the war of aggression carries a cost, carries a high cost, which the offending country must pay. Thus, the creation of the effective mechanism to obtain reparation, including compensation, not only by the state, but which suffered the aggression, but by the very victims of this blood-on war, is legally justified. If Russia is not accepting to make reparations in accordance with the provisions of draft articles on state responsibility, the reparations obligations must be enforced. Ukraine and its economy will need to begin reconstruction as soon as possible, and enforcement cannot wait for a post-war treaty or resolution because it's simply unrealistic to believe in goodwill of Russian leadership or wait for the capitulation of Russia. Russia's aggression has inflicted catastrophic destruction and suffering in my country. Tens of thousands of Ukrainians have been killed, many as victims of Russian war crimes. Thousands have suffered terrible, brutal abuse, torture, sexual violence at the hands of Russia's soldiers. Missile and artillery strikes, aerial bombardment, and kamikaze drone attacks have devastated major cities, including Kharkiv, Kherson, Kiev, Mariupol, Severodonetsk, exacting an enormous material and human loss. The estimates made in February this year by the World Bank shows that the cost of reconstruction and recovery in Ukraine has grown to $411 billion, and this does not include the consequences of undermining and complete destruction of Kakhovka hydroelectric power station. Given the scale and gravity of these harms and the critical need of documenting and assessing the extent of the destruction, as well as fixing the victims' claims to obtain reparation, UNGA strongly recommended to the member states to create an international register of damage. Such a register have now been established by the enlarged partial agreement of the Council of Europe. The register will have its seat in The Hague, the Netherlands, with its satellite office in Ukraine. The register has been established in the form of international legal entity and is envisaged to serve not only as a set of data and documents evidencing the caused harm, but also as a platform for intergovernmental cooperation between its member states. The register has already two of its governing bodies, the Conference of Participants, consisting of 42 states plus EU. As of today, 37 states have already become participants of the register, and 6 also became its associate members. And the recently appointed executive director, whom I am pleased to introduce today to you, Mr. Markian Klyuchkovsky, the nominee from Ukraine. The executive director and the secretariat shall ensure day-to-day operation of the register and collection of claims. The election of the board members is expected to be held before the year ends by the Conference of Participants. According to the statute, the board shall be composed of 7 board members, 1 of which to be nominated by Ukraine, 6 by the parties of the EPA. The board shall verify the evidences submitted for admissibility and include the claims into the register. Once all the statutory bodies are at place, rules and procedures are developed and approved, the register will start collecting and recording the claims and evidences on the damage, harm, and injury from the victims, individuals, municipalities, and the states, caused within the territory of Ukraine on or after 24th of February 2022 in the result of Russian aggression. Despite the fact that the register was founded by the Council of Europe through an enlarged partial agreement, the founding members are both the member states of the Council of Europe and non-member states. The register has been established as a global organization. That being said, the EPA is open for any state that voted in favor of the resolution to join the register as a participant or associate member. Needless to say that the Register of Damage for Ukraine is the first practical step and real measure taken with the aim at ensuring the victim's right to obtain reparation in armed conflict. The register is not about the politics. The register is about the victims and data collection on damages caused on a scale not seen since World War II. In order to restore justice, recover the destroyed Ukraine, the entire democratic world has already united and made a lot of efforts to protect international order and justice. Ukraine calls for a decisive international response by all democratic states whose sacred values are democracy, rule of law, and human rights that respect the territorial integrity and sovereignty of a sovereign democratic state, to show a principled position in this regard and join the Register of Damage for Ukraine. Because Russia's conduct is a serious breach of peremptory norms of international law affecting all states, all states are entitled to address it, including by ensuring that Russia satisfies its duty to compensate injured states and victims. Your Excellencies, I would also like to remind that the establishment of the register constitutes a significant but just the first component of a future international compensation mechanism. explicitly invoked by the UNGA in the November resolution. The latter called for member states in cooperation with Ukraine to establish an international mechanism for reparation for damage, loss, and injury arising from the international wrongful act of Russian Federation. And as it is explicitly provided in the statute of the register, the latter is an integral component of a future international compensation mechanism. And this is the first point where victims could seek justice. The register will remain only a mere database of evidence and claims if further steps towards the implementation of the international compensation mechanisms are not taken. As I mentioned above, the register is expected to become an intergovernmental platform for discussion of the next steps to be taken by the states following the measures recommended by the General Assembly of United Nations to establish an international compensation mechanism for reparation for damage, loss, and injury arising from the international wrongful acts of the Russian Federation. Ukraine, in its turn, will propose to consider conclusion of an international treaty aimed at addressing the consequences of the Russian aggression against Ukraine, imposing the obligation on Russia as an aggressor state guilty of launching and conducting a war of aggression. We believe the international law on treaties provides grounds for imposition of obligations, and the consent of an aggressor is not needed to establish an obligation to it under a treaty to which the aggressor state is not a party. Appropriate justification by norms of international law will be provided to the interested and willing states as soon as we start discussion on the international treaty. And it goes without saying that an appropriate and strong foundation should be developed in order to reinforce the legitimacy of such treaty and consequently the legitimacy of a contemplated reparation mechanism. The treaty will also provide for the establishment of an organ like a claims commission, especially dedicated to consider compensation claims fixed in the mentioned register of damage, and the compensation fund from which the compensation shall be paid out. The source of filling the fund must be Russian assets. The last but not the least, on what we encourage legal teams of the interested and willing states to start discussion is the application of state countermeasures under international law. We believe that by explicitly invoking compensation and recommendations for national and international action, the November 2022 UN resolution strengthened the case for full state countermeasures. Under the international law of countermeasures, states may temporarily suspend the sovereign immunity that the Russian state assets enjoy. Taking hold of Russian state assets is an in extremis remedy, but it responds to an extreme challenge to international peace. It protects the rule-based and pacific objectives of the international order, which are enshrined in Article 2.4 of the UN Charter. Action is legally justified to provide reparations, including compensation. It also serves as a policy of deterrence. Any state considering in future war of aggression will see that Russia's egregious violation of international order carries a cost. And this is what is of essence for every democratic state. Therefore, we expect that state parties to the enlarged partial agreement and those ones who voted in favor for a November resolution use the platform of the register for the development of the international mechanism for reparation and the proper legal foundation for using Russian central bank assets as the means of compensation to the victims of Russian aggression and reconstruction of Ukraine within the framework of the international compensation mechanism. The more collective efforts we make, the sooner we will force Russia to leave the territory of Ukraine and bear responsibility for all international crimes. I thank you very much.
Thank you so much, Madam Minister. Now the floor is to Mr. Marki Jan Kluczkowski, Executive Director of the Register. Please.
Good afternoon, Your Excellencies, ladies and gentlemen. It's a great pleasure to be back in New York and speak to you about these important topics. I recall the long hours and days and weeks spent here last summer and last fall when we spoke to many of you and your colleagues about what became the General Assembly resolution of 14th November 2022, about remedy and reparation to Ukraine, whereby the General Assembly essentially endorsed the concept of a compensation mechanism that was proposed by Ukraine. As you have heard from Ukraine's Deputy Justice Minister, today we can say that the first step envisaged by that UNGA resolution, the creation of an international register of damage, has been accomplished. It exists. And now we have to operationalize it, put it into action, and make sure that it starts working. And hence, I speak from a point of view of significant additional responsibility in my new capacity, having this duty vested to me by 43, I should say, member states to lead that role. However, looking back into the discussions that we had over last fall, I'm happy to say that what was then concept is now reality of the Register of Damage, effectively without any significant changes. All the key elements of it remain the same. The only thing that did change that is worth highlighting and emphasizing is the form of an instrument by which it has been established. We had envisaged that we would have to enter into an international agreement, a multilateral instrument that would take inevitably considerable time to negotiate, adopt, and put into force. That is where we had a little surprise, I can put it that way, from the Council of Europe that came forward and proposed to use one of their own cooperation forms that has an unusual name of enlarged partial agreement. It is not a treaty, but it does carry a certain organized form of cooperation of states that are both members and non-members of the Council of Europe. Why was this important to us? It was important because, as we had emphasized in the run-up to the UNGA resolution, that we see the reparations mechanism and the Register of Damage as a truly global, truly international exercise that is not restricted by the limits of one region or one continent, but it is something in which all the states in the world that hold dear the principles of international law should be able and should be encouraged to participate. And that form of enlarged partial agreement does indeed allow for that broad participation. It is indeed not restricted to the members of the Council of Europe, but it is open to practically any states in the world. Those states who have voted for that resolution in November, the 94 states, can participate, can join the enlarged partial agreement for creation of the Register of Damage by simply sending a letter to the Secretary General of the Council of Europe. It's as simple as that. All the other states, including those who have abstained from that resolution, can also join if they feel like this is something in which they can participate, but they would also have to be admitted by the Conference of Participants. As Deputy Justice Minister has said, the purpose of the register is to serve as a record of all the claims for damage, loss, and injury caused by Russia by its war in Ukraine, as well as underlying evidence. Its purpose, in effect, is to serve the foundation upon which the future compensation mechanism, a future claims commission, will conduct its activity, evaluating the claims and assigning compensation for each individual claim. The important issue about the register is that it has no adjudication function. The register will not determine liability or the size of that liability. It also will not evaluate the size of the damage or the size of claims. What it will do is it will record claims that respond to three very basic prima facie criteria. These claims have to emanate from damage that was caused in the territory of Ukraine. That includes territories that are temporarily occupied, such as the eastern and southern parts of Ukraine, including the Crimea. This damage must emanate from events that took place on or after 24th of February 2022. And this damage must have a link with the Russian aggression. If the claim satisfies these three basic criteria, it will be properly recorded in the Register of Damage and await its adjudication by a future claims mechanism that is yet to be established. For the purposes of this work, the Register of Damage will have, or is beginning to have already, three main bodies. The first body is the Secretariat that is headed by the Executive Director that will do effectively all the heavy lifting. Its purpose is to organize the system of intake and collection of all the claims and evidence so that everybody had possibility to make that submission. It will also organize and categorize and group the claims where appropriate and make certain recommendations as to whether or not these claims or individual claims or group of claims are to be included, are to be recorded in the register. They will also make these recommendations to the second body that is to be established within the confines of the register, that is the board of the register, that is ultimately responsible for making decisions about inclusion of claims in the Register of Damage. The board, as we have heard, will consist of 7 members, or I should say at least 7 members, because depending on the workload, on the size of the registers and register and the number of claims, there may be need to expand the composition of the board to address the workload for its individual members. The members of the board are to be professionals in their fields, in international law, in dispute resolution, in war claims and damage, in assessment of damage, and have, of course, needless to say, sterling reputation and integrity. The board, and this is very important, is to be diverse in terms of geography, in terms of gender, in terms of professional backgrounds. Finally, the third body of the register is the Conference of Participants. That is the conference of all states that are participants or associate members of the register. The inaugural meeting of that conference has taken place in Strasbourg on the 27th of June, just a couple of days ago. Every state that joins the register is entitled to be represented in that body. The seat of the register will be in The Hague. Here I would like to say words of thanks to the Dutch government that have been very helpful in various formal and practical matters of setting up the register in the capital of international justice. And if everything goes as quickly as it goes right now, by the middle of next month, by the middle of July, there will be a host state agreement concluded between the Council of Europe and the Netherlands, firmly setting up the register in The Hague in full of its rights. And because of that, well, not because of that, but as a consequence of that, and as was designed by the statute of the register, it will function. It is obviously a body that is established within the institutional framework of the Council of Europe, but it will also operate as an autonomous body, sort of within its own under its own roof, within its own ecosystem, having its own budget, its own payroll, its own management system that I've just briefly touched upon. The goal behind the register and the entirety of the compensation mechanism is to try to set the foundation for compensation of damages that is as broad as possible, as comprehensive as possible. I will tell you nothing new because we've said this all back in the fall of last year. The purpose is for this register to include claims by individuals, by legal entities, and by the state of Ukraine. They should cover everything from loss and destruction of property to loss of life, torture, deportation, forced removal, to various other violations of human rights, destruction of historic and cultural heritage, damage to the environment, which was particularly highlighted by the recent events in Kakhovka. Pretty much everything that Russia damaged in Ukraine is to be recoverable, and that is the point. That is the point of the register. Now, the true purpose, to be honest, of this meeting is to convince those states that are not yet parties to it, not yet participants to it, to come and join it. Almost all of European states are already in, and I realize that a lot of colleagues in this room are not hearing all of this for the first time and know these details to some extent. But as I said in the beginning of my remarks, the goal is to make sure that the representation of global community in the register is as broad and as diverse as possible. There are three ways states can participate in the register. The first form of participation is called exactly that, the participant. This is the most complete form of participation, if I can put it that way. That is when the state commits to participate in the register fully on a long-term basis and commits to make contributions to the budget of the register on a regular basis in the amounts assessed by the register itself. The amounts are assessed on the basis that is familiar to many of you, taking into account the population and GDP of each individual country. Of course, the amounts of contributions depend on the number of states participating, but as we said right now, the minimal contribution that is paid by the majority of states participating in the register is just over 25,000 euros per year. The second form of participation is the associate membership. The associate membership is when the state is not able or not willing to commit to full participation for a variety of reasons. In practical terms, those reasons are predominantly internal and the willingness to or not to go through complicated domestic procedures. The associate member does not, in principle, have the right of vote in the conference of participants. However, the associate member can attain that right of vote if it makes a voluntary contribution in the amount that would have been otherwise assessed had that member been a full participant. In that instance, the associate member attains a right of vote in the financial year during which that voluntary contribution will have been made. The third, obviously, and final form of participation in the register is the associate membership without voluntary contribution of that size. That is basically if a state is simply willing to participate in this form as a token of political, moral, and principle support to the purpose that is pursued by the register. The state, as an associate member, can participate in the meetings of the Conference of Participants without the right to vote, but with the right to make written and oral interventions and to otherwise participate in the work of the register. Why am I telling all this? Is because, as I said, we had the inaugural meeting of the Conference of Participants, but it was a fairly small one, if I can put it that way. The next one will be a little bit more meaningful. It will take place on the 12th of September in Riga, in Latvia. Issues discussed there will include adoption of the budget. That also will carry the decision about the size of contributions of each individual participant and associate member where it applies. And it also will commence the procedure of appointment of the board, where every state that is participant or associate member can nominate up to 3 candidates for the position on the board. For those states who join the register ahead of the meeting of Conference of Participants on the 12th of September, will be able, obviously, to participate in the conference, participate in the adoption of the budget, and after that participate in the procedure of nomination and adoption of appointment of the board members. And finally, before I speak too long, all this work is done bearing in mind that, again, as was said a couple of times already, the register of damage is just the first step towards the full compensation mechanism. Because the database of claims and evidence, no matter how beautifully organized, is meaningless if it is not followed up by an effective mechanism through which the victims can be ensured of full and effective compensation of damage suffered. So the Register of Damage can become a platform, and that is effectively written in its statute, for cooperation of states for the purposes of discussion of how that compensation mechanism will look like. Throughout the summer, we will work together with Ukraine on developing specific proposals in the form of perhaps a draft instrument, in the form of various memoranda and notes about various interesting issues, interesting for the most part for lawyers, that are required to be discussed before we can get into that conversation in earnest. But the intention is to commence a full and open discussion about an instrument concerning a claims mechanism as early as September. So, as they say, please watch this space. There will be news. We do encourage you to participate in this process as much as possible. We do encourage you to spread the word, especially here in the United Nations, especially among the non-European states, about the Council of Europe and the Register of Damage. We do want a lot of states, as many states as possible, from the Americas, from Africa, from Asia, from Oceania, to participate. There is no distinction from our perspective between European and non-European states, notwithstanding the fact that this is under the auspices of the Council of Europe. We do see it as a global response in the name of international law against the horrors of Russian war. Thank you.
Thank you so much, Executive Director, for this very comprehensive introduction. We wish you success, and of course we are here to support your efforts. The next speaker is DPR of Iceland. Please, Tondur.
Thank you. Excellencies, colleagues, we are very pleased to co-host today's event with Ukraine, Latvia, and Liechtenstein, and particularly welcome the presence of the Deputy Minister of Justice of Ukraine and the new designed Executive Director of the Register of Damage. A strong and unified international legal response to the aggression against Ukraine is needed, and all victims, as well as the state of Ukraine, must be able to fully realize the rights to truth, justice, reparations, and to guarantees of non-repetition. After the adoption of the UN General Assembly resolution on remedy and reparation for aggression against Ukraine last November, the Council of Europe, an important regional cooperation partner of the United Nations since 1951, heeded the call for the creation of an international register of damage in cooperation with Ukraine. The Council of Europe, as a Europe's guardian of human rights, democracy, and rule of law, and its framework of legally binding instruments, many which are open for accession for countries beyond the European sphere, was considered uniquely placed to carry out this task, especially in the light of its expulsion of Russia from the organization in March 2022. Iceland held the presidency of the Council of Europe's Committee of Ministers from November last year until May, when the helm was handed over to Latvia at the 4th Council of Europe Summit of Heads of State and Government, which was held in our capital, Reykjavik. Support for Ukraine was front and center during our presidency, and we are proud that it was also front and center at the summit, which was attended by a great majority of Europe's leaders. The summit concluded with important decisions in support of Ukraine, including on the situation of children of Ukraine and the commitment to the core values of the Council of Europe, those of human rights, democracy, and rule of law, as well reflected in the Reykjavik Declaration. Most notably, at the summit, an enlarged partial agreement establishing the Register of Damage was adopted and immediately supported by 45 states. The enlarged partial agreements of the Council of Europe are not only open for participation for the organization's member states, but also to other states in accordance with the register statute, and there are different types of membership that allows for the great flexibility, as was clear from the executive director here before. The brutal aggression is ongoing and extensive damage has been inflicted. It must be documented as a matter of urgency for the purpose of reparation and accountability. Ukraine's case for reparations is a moral and legal imperative which constitutes an important deterrent for the benefit of the entire global community. Iceland and the Council of Europe and its leadership must and will remain committed to ensuring that the organization will play a leading role in the development of a future international compensation mechanism. We wish Latvia every success in implementing the register, and it will have a strong support from Iceland. And finally, but not least, we urge UN member states to join the register to ensure justice for all those who have suffered damage, loss, or injury in this unprovoked war of aggression. I thank you.
I thank Iceland for the statement, and also to thank Iceland and Ireland for the recent co-facilitation of GA resolution on the cooperation between Council of Europe and the United Nations. Now I would like to say a few words on behalf of Latvia. Dear colleagues, Latvia is proud to be among the founding members of the Register of Damage, and it is also our priority of the Latvian presidency at the Council of Europe to implement the decisions made during the summit in Reykjavik. We are pleased to see the progress made towards registers of damage since May 17, 2023. I have the honor to highlight that on 11th of September, the informal conference of the Ministers of Justice of the Council of Europe will take place in Riga, Latvia, and it will serve as an inaugural platform for the register's operations. It will present an opportunity for the executive director to make his first public statement before the ministers, outlining the strategic orientations of the register's work. During the Riga conference, discussions will revolve around the forthcoming steps required for ensuring comprehensive accountability for the crime of aggression and the effective functioning of the register as the first element of the international compensation mechanisms. The primary focus of the conference will be to discuss the implementation of the decisions taken during the Council of Europe summit in Reykjavik. The aim is to explore how the Council of Europe can enhance its contribution in supporting Ukraine in re-establishing the international legal order by ensuring comprehensive accountability amidst the backdrop of Russia's aggression. At the end of the conference, a political declaration will be adopted. It will include a set of fundamental principles that will guide the work of the Register of Damages. I would like to encourage those countries who have not yet joined the Register of Damage to join by September 11th, according to the agreed procedure. During the conference, countries will be able to sign a political declaration and participate in the second meeting of the state parties of the Register of Damage caused by aggression of the Russian Federation against Ukraine. That will take place, as I said, on September 12th in Riga, Latvia. Latvia reaffirms its steadfast support to Ukraine as they strive for a future marked by justice, accountability, and sustainable peace. I thank you. Ladies and gentlemen, now I would like to open a Q&A session. Some of you have nameplates, some don't. So those who don't have nameplates, please identify your country, your mission you represent. And I would like, as a first statement or question, give the floor to the co-sponsor of this event, PR of the Netherlands, Joka, please.
No, thanks very much. And let me start by thanking you, Deputy Minister, for being with us here today, and also the Executive Director in his new capacity, and my colleagues for their presentations and reflections. And the Netherlands is glad to be co-sponsoring this event. And of course, in this particular case, we are proudly acting as the host state for the register, but also because we are co-chairing the group of Friends of Accountability following the aggression against Ukraine. And thank you for your kind words, Mark-Jan, and I can assure you of our continued and full cooperation in the process. We're proud to be the host state because establishing and strengthening institutions like the Register is in line with our Article 19 of our Constitution that specifically states that our government has a duty to promote the development of the international legal order, but also because we consider the Register to be a real crucial element in the process of establishing accountability for the serious violations of international law and the atrocities committed by the Russian Federation. And the Minister, I think you really spoke eloquently about the scale and the gravity of those violations and why this is such an important initiative. As others have said, we feel that it was important that 94 states actually supported the resolution that provided the basis for this process, and we really appreciate all the efforts and the steps that were taken since November, the adoption of the resolution, particularly grateful also to Iceland and the Council of Europe for facilitating the process and for the support expressed by over 40 states now and the European Union. And I agree that I think what you just said in your opening remarks, Sergei, that it's really important to have this meeting because we want to share information and follow a transparent process and this, but also to join others in using this opportunity to call on other states, to join the Register if they haven't done so. You really pointed out the various ways that that countries can join, and we really call on everybody who hasn't done so to do that quickly. And finally, we fully agree with what both of you have said, that the Register is an important step, but it's just a first step. Of course, it's important to register the claims, but it's not enough, and we really need a full compensation mechanism for reparations with both a claims commission and the fund besides the Register. And I think the states that met in Reykjavik have already pledged to continue working towards such a mechanism. Indeed, watch this space. As you said, we realize that this is going to be a road that will be full of challenges and obstacles, but again, sometimes we have to do things not because they're easy, but because we need to do them. And I thank you.
Thank you so much, Joke, for your statement and for very strong support of the Netherlands to this effort. The next speaker is PR of Guatemala. Maria Carla, please.
I want particularly to thank the Vice Minister of Justice of Ukraine, the Special Advisor of the President, and the Permanent Representative of Ukraine for sharing with us these important first steps toward accountability. But I also would like to thank representatives, colleagues of other countries that are convening us today. First, well, my country was honored to join Canada and the Netherlands as the core group on the resolution ES 11.5, which enabled somehow this important register to have a life. And so we are really very pleased that it is already in motion as a first step. And that Special Advisor to the President has been a so please count on all of our support. I wanted also also to ask a little bit about being open to any state who voted in favor, or at least a state in that important resolution. Who being a founding member and a participant or associate members, right? And if I will understand, it's mainly on being able or not being able to have an annual contribution, right, to the institution, to the register. I would like to ask, what does voluntary contribution mean? Does it necessarily mean financial contribution, or it can be another kind of contribution, for example, I don't know, secondments of prosecutors, or another way of contributions that is not necessarily financial. And lastly, but not least, being very happy that this meeting will take place on the 12th of September in Riga. I understand that it will be still possible for countries after that conference to join also. You are only making a call for the 11th of September, probably to have a larger number of participants, but I guess it will still be open after that conference, just for confirmation. Thank you very much.
Thank you so much, Maria Carla. Would you like to respond instantly?
Yes, thank you very much for your question. A couple of things. The contributions, so the register is financed by the contributions of its member states. So all the secretariat and the board activity is financed through these contributions. The difference between participants and associate members is that participants commit to make contributions on an annual basis in the amount that is assessed by the register on the basis of the criteria that I mentioned. Associate members do not have that obligation. Associate members can, and if I can be honest, are encouraged to make voluntary contributions. The form of which can be very different. Of course, a financial contribution is critical, but we could also conceive of contributions in kind. The things that we have discussed with some of our colleagues are contributions by way of consultancy, experts, technical assistance, contributions towards the IT platform in the services of various companies and things like that. So really quite anything, we can be quite flexible, really anything that can be useful in the work of the register and going forward. Of course, again, if the associate member makes the contribution that is of a size that is equivalent to what would have been assessed had it been a participant, then that associate member attains full participation rights, including voting rights in the conference of participants. As to joining the register, of course, it remains open. There is no deadline to join the register. Of course, we encourage the states to join and to join as quickly as possible. Particularly in time for a period when the critical initial decisions are to be made, including the adoption of the budget, nomination of the board members, election of the board members, and similar things. So it will be a process that takes, let's say, from now until the end of the year before the register becomes fully operational. And from our perspective, the more states participate already now, the better it is also for the issue of legitimacy of the register and broad representation of its membership.
Thank you. The next speaker is PR of Sweden, Anna-Karin, please.
Thank you very much, Andres, and many thanks to the entire panel. Sweden is a founding participant of the register, and we certainly agree that this is an important first step to ensure compensation for Ukraine, but also a signal from the international community that impunity is not an option. I wanted to follow up on what was said about the importance of having broad international participation. And of course, we are fully ready to participate in any reach out to try to get as many states as possible to support this. So I was wondering if you have any comments on how we could do that, how we could work here in New York and in our capitals to try to get as broad support as possible for this important initiative. Thank you.
Thank you, Anna-Karin.
Thank you very much, and we do appreciate these efforts. In principle, we have three main avenues of outreach, none of which will be surprising to you. One of them is here in New York, just because everybody is represented here. Second is in The Hague, amongst the diplomatic corps represented in The Hague. And there already is a plan for the first meeting, along with our colleagues from the Dutch government, planned, if I'm not mistaken, for the 11th of July, to make a similar presentation for the ambassadors and diplomatic representatives of various states that are represented in The Hague. The third, of course, is bilateral, and this is where everybody can participate and use the breadth of their respective diplomatic networks in their own capitals, but also in missions across the world. And we encourage everybody to do that, to spread the word about it, and to encourage other states, and like I said, particularly non-European states, to join the register, to inquire about the register. Both my colleagues in Ukraine and I, and of course others in The Hague and elsewhere, are open for any kinds of inquiries, any kinds of questions. We understand that the Council of Europe and the Enlarged Partial Agreement is not something, or may not be something, that is familiar to everybody, so we're happy to answer all the questions that may exist. I want to highlight once again that the process of accession or joining the register is in fact quite simple. Most of the 43 members as of today were able to complete it, I think in under 2 weeks, ahead of the Reykjavik summit, of course under some deadline pressure, but nevertheless. So it is really, and it is designed to be easy to join, flexible to participate, and again to make sure that participation is as broad as possible. Thank you.
Thank you. The next speaker is PR of Lithuania. Rytis, please.
Andres, and I really sincerely thank all the organizers, Iceland, Latvia, Liechtenstein, and Ukraine, for holding this important event, and also I thank the briefers for these very comprehensive, their very comprehensive statements. And we also know that it's truly crucial to preserve all evidence documenting Russia's aggression against Ukraine, as it is imperative to hold Russia accountable for every atrocity committed in Ukraine and to ensure they are held liable for the damages they incurred. And therefore, the establishment of the Register of Damage sets the stage for comprehensive compensation mechanism for the victims of the Russian aggression. And I fully also concur with my colleagues Joka and Anna-Karin that this is the first step, of course, about establishment of the Register. But then it would be important also to get your ideas and perhaps the next steps of how you're thinking of developing of the compensation mechanisms, and again also this compensation, ensure a fair and effective process of compensation to the victims. I do understand that this is not really the first step as such, but the ideas might be interesting to hear from you how you would approach this. These issues. From the personal perspective, once you mentioned about the establishment of the Secretariat, I would also strongly advise to look at the strategic communications part of that. Small team, but it will be really essential that the messages will get across, and I do believe that there might be a lot of efforts to discredit this mechanism. So this is important. And of course, we look forward to informal conference of European Justice of Ministers in Latvia in September.
Thank you, Rytis. The next speaker is PR of Czechia. Please, Jakub.
It's on. Well, thank you so very much. And, well, first of all, thanks to the organizers for convening this important meeting, and many thanks to the briefers. I mean, all the presentations that they've been very informative, I must say. Look, my country, Czechia, attaches great importance to the establishment of the Register of Damage. And we sincerely hope that it will move us closer to achieving justice and accountability for Russia's internationally wrongful acts, aka Russia's brutal and unjustified military aggression against Ukraine. I mean, our commitment is best demonstrated by the fact that the Czech permanent representative to the Council of Europe in Strasbourg, in fact, chaired the GRJ group that reached the agreement on setting up the register. And also a representative of Czechia was elected the vice chair of the Conference of Participants of the Register during its first meeting. And as you know, many of us here have stated, you know, however important this is, I mean, setting up the register is just the first step. And I have a question concerning a way of how to go about establishing a compensation mechanism. And Vice Minister, you've already touched on that, but I wonder, though, do you see any other legal options apart from a multilateral treaty, perhaps another enlarged partial agreement or a resolution of the UN General Assembly? So if you could elaborate on that a little bit more. Thank you.
Thanks so much, Jakub. Minister, please.
Thank you. Thank you, ambassadors of Lithuania and Czechia. Thank you very much. Well, unfortunately, an enlarged partial agreement, well, as of now, does not envisage to create a adjudicating body which will have the function of adjudication and impose obligations on the third state without its participation and its consent. That's why we see that there should be an international treaty concluded separately of the enlarged partial agreement, but the register will be the component for that treaty. And in the statute, it is envisaged that the members of the enlarged partial agreement, together with the executive director, committed to continue working on the international mechanism, compensation mechanism, developing the international treaty, and it is what Ukraine, what Mark Yan, together with his legal team, is working on. So we will provide the legal, advisors and to the member states of the register. The latest in September, the draft of the international treaty, our opinion on the possible legal grounds for the state to enter into this international treaty in order to have its legitimacy and in order to foresee the duty of Russian Federation to make reparations forcefully, not with its consent. So this treaty will envisage the establishment of a body, a claims commission. So it will be our proposal to have a claims commission, but it is up to for the discussion of the member states in which form this body should be created, and the compensation fund, because we have to find the legal grounds for taking hold of Russian assets. Well, it's not realistic that it could be done. In bilateral agreements, it should be an international tool which should serve the basis for confiscation of Russian assets, and we are looking deeply into the legal basis for this confiscation. And one of these grounds could be the state countermeasure, which I mentioned in my statement. So it could be as a international response of the global community to the breach of peremptory norms of international law and international order. So our expectation is that before the year end, we the participants of the register will start discussing the draft international treaty and the legal grounds which will lay into this treaty. We understand that the process of conclusion of the treaty it's quite long, because it will require ratification, unlike the EPA. In case if the member states become an associate member without contributions, it might probably not require ratification. For those one who will agree to pay contributions, it might require, but to join the EPA, the ratification is not needed, which is not like in the situation with the international treaty.
Thank you. Yes, please.
Just a quick thought to add to that, if I may. Getting a little bit technical legally for a second. Basically, there are two effective ways to establish legally binding obligations in international law. A Security Council resolution, which we understand is not possible, at least at this moment, and a treaty. From the process of discussion and adoption of the enlarged partial agreement on the register, we understood that it is not what the instrument called, but it is what is the substance of the instrument that determines its nature. And if states through the substance of that instrument determine that it is a treaty or a treaty-like instrument that requires ratification, for instance, then it becomes effectively a treaty process. We are absolutely keeping an open mind to see if there is any alternative to a treaty. If there is something that is easier to adopt, believe us, we will be the first to jump on that. But realistically speaking, it does look like a treaty is inevitable, unless, again, somehow the Security Council becomes unlocked. Never say never, as they say.
Thank you. The next speaker is DPR of the European Union. Please, Silvio.
Thank you very much, Andris, and thank you to the organizer for this briefing, and to the briefers, the Deputy Minister and the Executive Director. As you know, the EU is a founding associate member, and there are discussions now in Brussels to become full participant members of the register. So we are very, very supportive, and we joined the call in 2 other states, and we'll use our diplomatic channels to do this kind of outreach. But I wanted to join a little bit what Anna-Karin and also Rytis was saying. I think we also need to develop a narrative and a communication policy, because, you know, the space out there is not going to be very friendly at times. And as the Deputy Minister was saying, this register is important for Ukraine, but it's also important for setting the record straight in history, let's say. Also for, hopefully, not future cases, but also for that, I was wondering whether you're going to use modern technology to collect the massive amount of data that you will need, including artificial intelligence, in order to make this register really setting the standards, you know, for this kind of body, and how also you envisage ensuring the interoperability between the register and the future claims commission or compensation mechanism, or whatever we want to call it.
Thank you very much for these questions. I can only agree with what you said about the communications approach and the communications policy. That is absolutely inevitable. And in addition to having that firmly in our focus, also with respect to budget planning, staffing, to have a communications function within our staff, we do welcome any help, any coordination, of course, with the partners, with the members of the register and others, to really take that message forward, including in the places around the world that are not necessarily as welcoming of these concepts as we would like. On the issue of technology, the answer is yes, absolutely. We, as a matter of fact, from day one of our work, we have We have planned and still plan to rely exclusively on digital data. So we are departing from hard copy, from paper-based documentation as a matter of principle. It is both because we're in the 21st century, but also by means of necessity, because considering the number of claims and the size of damage, the register would simply drown in papers if we had chosen otherwise. So we do that, and for instance, one of the critical, the most important, and the most difficult initial functions of the register in this setup period is to build this digital platform that will hold this information and enable very smooth, seamless submission process from Ukraine to the register. And then from that on, we can build on existing functions. For example, we will align and coordinate with what I think everybody now knows, fairly advanced Ukrainian digital systems and the DIA application and various governmental databases and resources that exist now in digital form. And also the tools of data management, because once we collect that information, we have to process it. So from simple known things as a sampling and other statistical tools that have been successfully used in the previous databases, including in UNRWA and UNCC, to the use of artificial intelligence to go through the data, to group and categorize the claims, and to somehow facilitate the process of the processing of that information, because once again we're potentially dealing with millions of claims, and otherwise it will take many years. So we do want to take advantage of the tools that exist today, and we hope to be able to lead the way in terms of employment of these things in databases like this.
Thank you so much. The next speaker is Marie-Louise from Denmark. Please, DPR.
Ukraine for organizing this briefing. And the advisor of the Office of the President for outlining the plans for the register of damage, as well as the other necessary elements of the comprehensive compensation mechanism. Let me just say it's really quite impressive that it only took 6 months from the adoption of the resolution in the General Assembly asking for the creation of a register to the signing of the partial agreement within the Council of Europe. And this is really an achievement, and it seems that this both pace is being kept up. So this is really, really good. Denmark strongly believes that we must explore all possible ways of ensuring accountability for the crimes committed in Ukraine. And the register is an important, as many have said, first step, and we are, of course, a proud founding participant of the register. We will heavily participate in spreading the word to more states. It was very useful with the explanation by the advisor to the Office of the President of the different types of participation. As the Netherlands, we are also co-chairs of the Group of Friends for Accountability following the aggression of Ukraine. That works here and also in Geneva with 50 member states. So we will take forward in that, but also how we can enrich this group for our outreach. Thank you.
Thank you very much. I understand Moldova, PR of Moldova, Georgie. Did you ask for the floor or not? No. Oh, okay. Sorry. It's Malta, please.
Thank you very much, Chair. Thank you for the briefing, and to all the panelists. My name is Augustina Szyman, the legal advisor of Malta. My question is the following. Having served formally as a rapporteur of the International Law Seminar for the Working Group of Reparations for Individuals for gross violations of human rights and humanitarian law, do you envision somehow for the register to register also claims of moral damages of victims? Because one could only imagine the distress and the moral, how morally affected the victims of the war are. Thank you.
Thank you very much. As I mentioned in my remarks, the overarching idea is to make it a comprehensive system to potentially include everything, if I can say it that way. Of course, there's a certain point where the line has to be drawn, if only from the point of view of ability to somehow establish and quantify that damage. because we don't want that process to become arbitrary and evidence-driven. We want it to be evidence-driven in the first place. So while we certainly envision compensation for suffering, let's put it that way, in various forms and various shapes, we will have to think also practically how to make sure that it works from that perspective. And in the end of the day, the categories of specific categories of damage is something that the Secretariat of the Register of Damage will develop and the board will have to adopt. Until then, everything I say is basically just a draft list of categories. But again, I want to emphasize that the thinking is to make it as comprehensive as possible, and also, and it is indeed quite important, to leverage the work on various categories that had been done, including by various UN bodies and agencies. So in addition to work that you have been doing with your colleagues, we also want to rely on the work of, for instance, UNEP in assessing environmental damage, of the work of UNESCO in helping assess cultural and historic damage to cultural and historic heritage that obviously goes far beyond the physical damage to objects and property and things like that. So the register wants to be a little bit like a sponge to absorb all that knowledge, because it's really been a very long time since damage has been that widespread and that comprehensive. Thank you.
Thank you. We have 2 more requests for the floor, but the time is running out, so please, colleagues, be concise. Estonia, and then followed by Singapore.
It is both important in the sense that gathering evidence is crucial, but also the restoring of justice for the victims, as mentioned. My question relates to something that was mentioned by Ambassador Guatemala earlier on the contributions and voluntary financial contributions, and the answer to this question is duly noted. However, my question is, as you mentioned, different expertise as well. Is there maybe a list of expertise needed? You mentioned different aspects, but maybe this is also something to consider so that the member states will be able to contribute better. Thank you.
Thank you. Maybe I'll ask representative of Singapore to make his statement, and then you will have 1 last minute. Thank you.
Thank you very much. My name is Nathaniel Kung. I'm the legal advisor at the Permanent Mission of Singapore. I just had one question. I think all of us here, I think, recognize the importance of upholding international law. And in this context, I would just wish to know whether there could be any elaboration on what the envisaged treaty for the establishment of the Claims Commission, how it aims to deal with one key principle of international law, which is that treaties can only bind those that are party to it. I thought I heard from one of the briefings, I believe it's by the minister, that what is envisaged is some way in which obligations can be imposed on the Russian Federation via this treaty. Thank you.
Thank you. Arkian, please, if you could.
Of course. Very quickly, in response to a colleague from Estonia in the order of questions, that there will be clearly a list of expertise where contributions will be welcome, and we will clarify that list as we go into the operations of the register. But what is clearly clear now that will be necessary is expertise to establish the processes of the register itself. So, for example, relying on the experience of UNCC and UNRWA is our sort of main sort of source of expertise, but also in IT, in data management, in artificial intelligence. This is where there's considerably less resource, practical resource that we can rely on in terms of how this has been done in this context. So we will sort of have a kind of a first mover problem in the sense that we will have to learn by going in that sense. So any help and any expertise in that area we'll consider certainly will be very helpful. With respect to the treaty and the question from a colleague from Singapore, I don't really want to get ahead into detail right now because this work is ongoing, and as I said, over summer we will be developing these concepts in greater detail because until now we have focused on the register for the most part. But in most general terms, there are a series. There is a number of ways we can approach these issues. One of them. And I just mentioned a couple in no particular order without putting an emphasis of any of them. One of them is the concept of erga omnes. The Deputy Minister has mentioned that this, what Russia has done, is a violation of law with respect to each state, considering that an act of aggression in violation of Article 2.4 of the UN Charter is perhaps the most egregious violation of international law conceivable. There is also, there are other concepts. For example, the one that I have personally had probably the most fun exploring, if I can put it that way, is Article 75 of Vienna Convention of Law of Treaties, that allows departure from certain principles of the treaty law when it comes to an aggressor state. So quite a number of concepts that we'll be happy to explore and share our thoughts through the summer and into September before we get into practical conversations about it.
Thank you so much, Executive Director. Our time is approaching the end. For my behalf, I would like to thank you all for participation, and I hope that as many possible of you, your delegations will be present in Riga in September. And now I would like to pass the floor to Christian, PR of Liechtenstein, to make some concluding remarks. Thank you.
Well, thank you. Thank you so much. And thanks for our briefers for really enriching and very detailed presentations. And congratulations to you, Mark-Jan, for your new job. Big job, and we will fully support you in it. We are also a participant in the EPA. We will be taking over the chairmanship in the Council of Europe in November, and this will be a priority for us nationally, both at that time and before. It seems to me there's really two things that are key in moving this forward, and one is the issue of ownership that Anna Karin and others have mentioned. I think it's extremely important to continue the conversation that we have commenced here today, and to reach out to states outside of the Council of Europe, and to invite them to join this. To have political ownership of this, I think, is enormously important for its standing, and also for this. I mean, this is also a bit of a model and a precedent for the future. It's something that has not been done in this way before. So I think we should make every effort possible to also benefit from the fact that there are different modes of participation, including those that do not come with financial costs, even though, of course, we would be very happy to see states contribute financially. But it's a concerted effort. It's not obvious to everybody that an effort that was launched within a regional organization is open to the entire international community. Not everybody will understand that. It's not something that is done all of the time. So I really think we have to go about this very systematically. And the second is, this was done efficiently and effectively because people pulled together, and it's a really impressive piece of work, and it's only the beginning. So the Claims Commission is what is really needed to give this any meaning, as Mark-Jan has said, and to give us the return on the political and financial investment that we have made here. And it will be the more difficult part of the exercise, And it's something that, again, I believe we should involve or to create the strongest sense of ownership as possible and that's a conversation that we very much look forward to being a part of. So thank you all very much. This is, of course, a little bit full circle because this started at the UN with the resolution in November. And I'm really grateful to everybody who was able to join us today, but in particular to our briefers, because I think they have really given people a lot of material and a lot of knowledge and a lot to report home to. So thanks, everybody.
Thank you so much, Christian. We are very good on time, so we are concluding now. And see you in Riga. Thank you.